morning, everybody. A very warm welcome to this morning's Construction and Engineering webinar, which is our summer update. My name is Stefan Harris-Wright. I'm a partner in the Construction and Engineering team at Burkitt's Solicitors. If we could have the next slide, please. So I'm joined this morning by three of my teammates, and they are Emma Chiaramello, Patrick Cooney, and Nicole Clifford, all of whom are colleagues from our construction and engineering team. If we could move on to the next slide, please. So hopefully most of you will have heard of us at Burkitt's before, but just in case you haven't, there's some information at a glance for you up on this slide. I won't take you through all of it in detail, but just in summary, we are a full service top 50 UK law firm. We've got 6 offices across the UK. We're in the east of England, London and Kent. And if you follow the business press, then you might have seen recently that we announced that we'll be opening a 7th office over in Bristol later on this year. So as part of our firm, we've got a specialist construction and engineering team of 16 colleagues, and we advise on transactional, non-contentious and contentious construction matters. If we can move on to the next slide, please. So just to briefly kind of summarize on the content for this morning's session. So Emma's become something of our team's kind of resident expert, if you like, on the Building Safety Act, and you may have been with us for some of our earlier webinars where Emma's given regular updates on all things Building Safety Act. So Emma's got an update on implementation of further aspects of that legislation since we last heard from her. Patrick's going to be talking about some key aspects of the JCT 2024 suite of contracts, which I'm sure many, if not all of you, will be aware have recently started to be published. And then we've got Nicole, who's going to give us an update on some recent interesting construction and engineering cases. And then we've allowed some time at the end for a bit of a Q&A session. So before we get into the sort of meat of the webinar, I've got a handful of sort of housekeeping points for you. So there's an opportunity to put your questions to our panel through the questions function in the GoToWebinar portal. The questions come through to me and not through to the panelists or the delegates, so you will remain anonymous, so don't worry, please don't be shy. Feel free to send in your questions. A few people have sent in questions in advance, so many thanks for those. We've had a fantastic turnout for today's session, so I can't promise we'll have time for all of the questions, but we'll certainly do our best to get through as many as we can in the time available, and I'll look to draw proceedings to a close promptly by midday. Last thing to mention is that we are recording the session, and that recording will be circulated in the coming days to delegates along with a copy of the slides. Okay, that's it from me for now. So if we could move on to the next slide, please. And without further ado, I will hand you over to Emma.
Hello, everyone. Thanks, Steph. I'm going to be talking to you today regarding the some of the latest changes with the Building Safety Act. We did discuss it, I think, back in October, and there are a few points to update on that. Next slide, please, Natalie. So just to recap, because I'm conscious that some of you will not have all of the background knowledge on the Building Safety Act, and it has also been said that the Act is something that people either get or they don't, and you may be part of the latter category. So just to summarise in probably the most succinct way possible, it applies to all buildings. There's a more onerous regime for higher risk buildings, and they are defined as buildings that are either 7 stories or more, 18 metres or more, provided there's 2 or more dwellings, or if it's a hospital or a care home and it meets that height threshold. Another key factor is that everybody involved in design and construction is formally a duty holder. That is imposed by statute. It's not optional. So if you're involved, you're a duty holder, unless you're a trainee, because you can't be a duty holder as a trainee. And your duty as duty holder is to take all reasonable steps to reduce the risk of fire spread or structural failure. And that is, in fulfilling your role, you have to take all reasonable steps. So it's part and parcel of your role. This is a statutory requirement, which means that most of the construction contracts or consultants appointments that you will have signed up to will require you to comply with it because it's a statutory requirement, and it's additional to any duties that you have under the CDM regulations. Competency is a massive thing under the Building Safety Act. The Building Safety Regulator has been set up, and they are taking a lead on trying to drive competency standards. There is a competency steering group now, which is part of the Building Safety Regulator, that has set up 13 cross-sector working groups, and there's been great strides made towards prescribing key frameworks for different trades and specialisms within the industry, but there's still a lot to be done on that. It's only the fire safety regulators that have got a qualification framework in force. There are other new BSI and PAS standards which have been devised, but the real challenge is going to be an implementation of those new standards and frameworks, and there's a big push on that. And evidence will be required by the Building Safety Regulator in due course, bearing in mind they currently have got a large task on their hands of reviewing the existing housing stock of high-risk buildings and remedial works in relation to those. One key factor to be aware of with the Building Safety Act is that it is possible for criminal sanctions to be applied to all officers of the company. So that's not just legal directors, that's all company officers, and you could have unlimited fines and up to 2 years in prison if you are seen to be obstructing or otherwise not complying with the Building Safety Act. There's also the risk that works could be put on stop and planning building control approvals may be withheld, for example, on existing projects, which obviously carries significant financial considerations for all involved. There is an increased risk of civil claims for building safety risks and defects as a result of the Building Safety Act. Because of various reasons, there are more bases to claim legally, more grounds of claim. They've got more time to claim because the limitation periods have been extended. And there's more scope for you to pursue different defendants to find somebody with some money to sue, basically, because you've got these new building liability orders and also remediation contribution orders. Next slide, please. So looking at the more onerous regime, which is part of the Building Safety Act for higher risk buildings specifically, the new Building Safety Regulator is building control for these buildings. There may be private building control companies working on existing construction projects for higher risk buildings under the transitional arrangements, but that ended in April of this year. So all new projects are to be progressed with the Building Safety Regulator acting as building control. There are 3 gateways for high risk buildings. These are really checkpoints where you need to seek approval from the Building Safety Regulator, and that is during the planning phase, before building, and before anyone occupies the building. Ongoing golden thread requirements are relevant for high-risk buildings as well. That needs to be accessible and stored electronically and kept updated as things change in the building. And it's not just a one check and you're done with the Building Safety Regulator. Once the initial workload of becoming established and checking every existing building is done, which is no insignificant task, they do plan to review all high-risk buildings at least once every 5 years, and that would be for the ones that are least risky. So if there are any concerns, it would be reviewed more frequently, and that is the plan for the high-risk building regime. Next slide, please. So just to summarise then the different regulators that have been brought in, and the Building Safety Regulator is the main one, which we've looked at. As I've said, they're driving competency improvements by the Competency Steering Group, which is now part of the regulator. They're also regulating building control. They're not just building control for high-risk buildings. They are bringing building control into a unified profession. There's a new code of conduct, etc., etc. There's also the National Construction Products Regulator, albeit that's slightly gone back to the drawing board further to an independent report in April 2023. And that's currently with the government's Office for Product Safety. But the intention is that's going to be similar to the Building Safety Regulator, and they're going to have powers to carry out on-site spot checks and seize goods, etc., which again could cause massive delays on construction projects. The New Homes Ombudsman is still really in its infancy. It's groundworks only at this stage. Because the New Homes Code is still only voluntary for developers, and the intention is that the Ombudsman will be set up to review complaints by people who've bought new homes or are planning to buy new homes, and their decision will be binding on developers who must come up with a remedial scheme, and the Ombudsman will have the power to award up to £75,000 of compensation on top. So that is really a case of waiting and seeing what happens and when that comes in. I think the intention was that it would already be in, but for various reasons it's been delayed. The New Homes Quality Code could very well become a sales kite mark in the future, or a requirement of new homes warranties or mortgages. So it's certainly something to be aware of. Really, the aim of these three regulators is to ensure that the industry learns from Grenfell and to assure all stakeholders, all parties living in high-risk buildings specifically, and also generally other buildings in regard to fire and structural safety. Next slide, please. Okay, to recap on timelines, April 2023 was when the groundworks were laid. All existing high-risk buildings had to be registered by the end of September of last year, and the bulk of the provisions came into force in October. New build high-risk buildings started to be registered then, and the Building Safety Regulator really started its work proper. There were transitional arrangements at the time for any high-risk building projects that were already in transit. And if there had been sufficient progress by the 6th of April 2024, then you could continue with those projects via a private building control company. Otherwise, it would revert to the regulator, and you would need to make the checks at each gateway to the regulator. Next slide, please. So some updates then. In January, we got more detail on the proposed building safety levy. That is intended to raise money for the Building Safety Fund, which is dishing out money for lots of vital remedial works for fire and structural safety when no one else can or will pay it. And this is going to be payable by all residential developments of more than 10 units. And it's going to be a requirement in order to get your building control completion certificate. And it will apply to all new accommodation buildings, so not just high-risk buildings, and be charged on a square meterage. The aim is to raise £3 billion over 2 years, and it will be reviewed on a 3-yearly basis. Next slide, please. So to sort of set the context of where we are at the moment, with BSA has been in force for 2 years now, and it's not been an easy climate by any stretch. We've had high interest rates, and there's been shortages on materials and labour. The transitional arrangements having come to an end has meant that impacts really now being felt by project teams, and costs and operational implications of the Building Safety Act are now being noticed really by developers because they can't be ignored anymore. So it's important to stay up to date and to sort of keep looking around the corner at what's coming, because if you get caught out, it can cost a lot of time and money. and there's also risks of fines, etc., if you're not complying. You can see that the regulators got a balance to strike with regards to encouraging construction of more housing stock, and also juggling improvements to existing, because it's dealing with applications for vital remediation to existing high-risk buildings, which I would suggest is its key focus at the moment, because there's so much of it going on. And there's also a shortage within building control, and I know that they are also trying to recruit themselves. Next slide, please. It has been said that the Building Safety Act requires an entirely new approach in design and construction, because of the additional time and costs associated with any significant changes that might require a fresh application to the Building Safety Regulator for approval. You know, you're talking sort of 6 to 8 weeks for the Building Safety Regulator to approve those, which could cause major delays. So really, you need to front load all of your design to the beginning of the project and seek it at Gateway 1 and 2, so planning and pre-construction stage, and then hopefully Gateway 3 will be significantly easier and there won't be unforeseen delays. Another long-awaited change, or long-awaited confirmation, is in regard to the when a second common staircase is going to be required. Now, originally the plan was for this to be required in buildings of 30 metres or more, but they've now confirmed that it will be a requirement for all higher risk buildings, so that's 18 metres or more, from September 2026. Now, there will be transitional provisions until March 2028, I'm told. But you know, this has attracted a lot of praise, a lot of criticism. It's going to cost a significant amount of money. It's notably cost about 80% more it's going to cost about 80% more to apply this to 18 metres or higher buildings as opposed to 30 metres or higher buildings. So yeah, it's a major consideration, and there's a risk that it could make certain developments unviable, because you know, with a second common staircase, you are going to reduce the amount of available floor space to be sold as accommodation. Interestingly, the consultation outcome commented that in other countries that where they'd mandated second common staircases, that these were mandated from 18 metres or and between 18 metres and 75 metres. So obviously there's a significant variance there internationally, and we are one of the leading countries to require that at 18 metres or above. Next slide, please. So going back to the increased risk of civil claims, we've mentioned that there's greater grounds of claim and more time in which to claim. So to elaborate on that a little bit, the main additional ground of claim is under the extended Defective Premises Act that was brought in 1972. And to put it in context, I think I've only come across it once pre-Building Safety Act on a live matter, an alleged breach of the Defective Premises Act. But it's now coming up all the time because it's extended to now cover works, all works to existing dwellings provided in the course of a business, whereas it used to cover only works in the provision of a dwelling. The duty under the Defective Premises Act is to build properly, which doesn't sound quite right, but that is what the statute actually says. You need to build properly and to ensure that the dwelling is fit for habitation as well. And the case law supports the view that fire and structural safety defects will contribute to a finding that the dwelling is not fit for habitation. There is a 15-year limitation period for Defective Premises Act claims. Typically, it was only 6 or 12 years for either breach of contract or tort. So that is a significant increase, and that retrospectively, for any claims arising pre the Building Safety Act, that 15 years is extended to 30 years. So we're seeing a lot of claims for buildings built a long time ago that are substantially defective, and we've had to get people decanted quite urgently for those. We've also got the building liability order procedure, which extends the pool of people that you can claim against, or claim pool of companies, shall we say, because in English law we have something called the corporate veil. You can't pierce the corporate veil by pursuing other companies within the developer's corporate group, and typically a special purpose vehicle was brought in, was incorporated to deal with a development, and then profits taken out, and the special purpose vehicle wound up when it was no longer required. That's not as easy these days because of the building liability order procedure. You can now pursue associated companies for building safety defects if they're linked to the company that developed the building. There's also the possibility of remediation orders and remediation contribution orders as between leaseholder and freeholder. So in that context, there are a lot of house builders and developers committing resource to reassessing their liabilities on historic and new projects by all companies within their group. Next slide, please. A couple of recent Building Safety Act cases. Get Living versus Triathlon Homes, that was January of this year. There was 18 million sought as a contribution for vital remedial costs for fire and structural safety defects. And a few key findings was that it was irrelevant that a lot of the remedial cost was incurred before the Building Safety Act came into force. The key thing with this decision really, though, is the application of the just and equitable test within the BSA. So this test applies to remediation contribution orders and also building liability orders, which is the main one that we're interested in from a construction context, because it means that we can pursue beyond any special purpose vehicle that may have developed relevant buildings. And the court will decide whether it's just and equitable to require the associated company to cover the costs associated with the remedial works necessary on a building developed by a company within its group. It is a test that the tribunal confirmed would be for review on a case-by-case basis, but in this case, the owners only acquired the buildings after they were built, and it really confirms that it's not a fault-based remedy. They had nothing to do with the development, and whilst the aim and objective of the building liability order process is to ensure that costs are picked up by the original developer, it didn't matter. The court still made the order. It didn't matter that there were other claims available either. They still made the order. And that is going to incentivize further claims deeper into the supply chain via the building liability order process as well. Next slide, please. So the other recent case is in relation to remediation orders. So this isn't a remediation contribution order, it's just an order sought by leaseholders who are utterly frustrated by the freeholders' delay in remediating safety defects. And interestingly, with this case, the works were actually in hand already, and government funding had been put in place in order to finance that. But the leaseholders applied regardless, and the tribunal made the order really to reassure the leaseholders. It knew that the works were ongoing, but it wanted to send a signal that freehold owners can't just sit back and delay these works, that they have to crack on with them. I think that's it for my presentation. So we can go on to the next slide, please, and I can introduce my colleague Patrick, who's going to talk to you about JCT 2024.
Thank you, Emma. If we could have the first slide, please. I'm going to summarise the changes to the new 2024 updates, the JCT suite. At the moment, we've only got the design and build contract and its subcontract and the minor works forms. So I'll focus on the DB contract because obviously not all the changes will be flowed down to the minor works, and we should get the other forms later this year. I'm going to summarize the sort of key changes, but if you want to see all of the changes of line by line, the JCT publishes a really useful resource on its website, which is a red line or track change version, which shows all of the 2024 changes as a red line against the 2016 edition. So you know, that's available on their website, an absolute bargain at £136. So if you've got any family birthdays coming up, definitely want to bear in mind. Okay, let's have a look at the next slide and have a look at some of the changes. One of the most obvious ones at the beginning of the contract is the JCT's clause on collaborative working. I've put the wording on the slide there, so I won't read it all out to you. It's not actually a new clause. The same wording did appear in the 2016 edition, but it was an optional provision, one of the supplemental provisions which you could choose to incorporate into the contract. So now it's been brought in as a new Article 3. It's a mandatory requirement rather than mandatory clause rather than optional. Have they just copied the NEC? Is it the same as the NEC? A lot of you will be familiar with the NEC's fundamental principle of cooperation and acting in a spirit of mutual trust and cooperation. It's quite similar to that, but there is actually quite a lot more in the JCT's clause. Beyond just trust and cooperation, you've got working with each other and with other project team members, so you know, non-parties to the contract. So it's wider than the NEC. And then at the end, you've got supporting collaborative behaviour, and then in terms of specific measures, addressing behaviour which is not collaborative. So it goes quite a bit further, and you know, TBC as to how it's interpreted by the courts. But I think the point to bear in mind with these sort of good faith collaboration type clauses is the idea is that they're not interpreted by the courts because they don't go that far. These clauses are all about changing mindset, you know, moving away from the old sort of traditional adversarial contracting approach and seeing yourselves more as partners and working together so as to, you know, resolve disputes before they become formal disputes and before you go to a formal process. So you know, very much in the NEC model. So that's quite a, you know, not a new clause, but quite a big change to put that in as a mandatory clause. If we could move on to the next slide. I've put on there the new clauses on sustainability and environment. Clause 215 there, which is a new clause in the 2024 edition. You'll see from the second bullet point again in my slide that it's not a new clause. Again, they've brought it in from the supplemental conditions. So again, it's mandatory now rather than being optional. And it goes a little bit further than it did before. The wording I've underlined shows what's changed. So it was that the contractor was to suggest, you know, economically viable amendments which could improve environmental performance. That's now extended to cover sustainability in the carrying out of the works, and also a reduction in environmental impact. So you know, the wording is just a little bit wider than it was before. I think the key point to bear in mind is it's now, you know, a mandatory clause rather than optional. And similarly, that new clause 222 on the slide there is the same as it was before, but has been brought in from the supplemental conditions. So the contractor provides the employer with all the information that the employer reasonably requests regarding environmental impact of the supply and use of materials and goods which the contractor selects. So that is exactly the same as it was before, but it's no longer optional. If we could move on, please, to the next slide. So Emma talked about the Building Safety Act in detail, and the new 2024 addition to the JCT suite does reflect the Building Safety Act. There are BSA changes, but they are quite limited. Emma talked about the new concept introduced by the BSA of duty holders and the duty holder regime, who have to take all reasonable steps to reduce the risk of fire spread and structural failure. And the definition of duty holders is wide, you know, those who procure, plan, manage and undertake building work. But the JCT's put in a new Article 7, so you can identify who is the principal contractor and the principal designer for the BSA, or rather for the building regs, which is what the BSA is amending here, in the same way as you would for the CDM regs. There's an amendments to clause 272, which require the employer to provide the contractor with building information. I've put the definition on the slide there, and the definition of that is very wide. But really, all they're doing is sort of reflecting the new duty holder regime. And interestingly, they haven't incorporated any amendments in the 2024 suite to reflect the new regime that Emma was highlighting about high-risk buildings, for example. There's nothing on that at all, which is a bit of a surprise. So they are quite limited, the BSA changes. Okay, on to the next slide, please. There is quite an interesting change for employers and contractors alike on design liability. So there's a new clause 217.1.1, which sets out the obligation in regard to design. The wording is a slightly expanded, bit different to what it was before, but it really hasn't changed. It's all quite market standard, and fundamentally it confirms that when contractors carry out design, reasonable skill and care is the relevant standard. But what it goes on to do, and this is the change, and in the next sub-clause, is the JCT now says that under no circumstances shall the contractor be subject to a fitness for purpose obligation. And you may well be aware that skill and care being the standard duty, because that's what the law expects, that's what the law would imply anyway, that being the standard duty, fitness for purpose and effectively guaranteeing the performance of a design, that it will achieve what it was designed to do, is going way beyond exercising skill and care, and is a much more onerous duty, and is unlikely to be covered by your PI policy if you sign up to that. It could potentially invalidate your PI policy, but that's very much subject to the terms, but it's highly likely to be uninsured. So the JCT now clarifies that contractors not expected to be subject to fitness for purpose when they're carrying out design. And they're responding here to a specific case. There was a recent case called MT Hogard, where the contractor on a very large project thought that they had signed up to skill and care, and that was their defence when a claim was brought against them for defects in the design of wind turbines, which they designed and constructed, and the conditions, the JCT conditions, did say skill and care and didn't reference fitness for purpose. But tucked away in the contract documents, in the ERs, way back in the ERs, there was a clause, a paragraph, which did require fitness for purpose. And the court in that case said, well, the conditions may say skill and care, but there's nothing to say that fitness for purpose is excluded. So we're going to interpret this, additional obligation as this provision in the ERs as an additional obligation to also ensure that the design is fit for purpose. So the JCT are responding to that very specific case and sort of clarifying that point. They don't go as far as suggesting as having an entry in the contract particulars for a cap on liability, which is pretty market standard now. Obviously, debate over the amount and basis and so on, but the footnotes do suggest that the parties might like to agree one, because they're pretty market standard now. Okay, if we could move on, please. There's a couple of new relevant events and potentially relevant matters. So an epidemic impacting the works is now a new relevant event. I've got no idea what they're responding to there, why they brought that in. It's almost as if we've been through an epidemic in recent years, but that's now specifically covered as a relevant event. And then interestingly, a nuance on a related point. There is already a relevant event, so an event under a JCT contract, which entitles the contractor to claim more time. There is already a relevant event for a change in law. Now, if you remember when COVID came in, it wasn't actually changes in law which were impacting the works and the way that we were living our lives. It was really the publication of government guidance. So that sort of plugs that gap. And both of those things, so publication of guidance, will now be covered as a relevant event. Both of those things will be relevant matters, but only if the parties specifically list them as such in the contract particulars. So you've got to choose for those things to be relevant matters as well. So the default position is that they're neutral events, more time, but not more money. Okay, if we could move on, please, to the next slide. A couple of points on LADs. So there's a new clause in the 2024 suite of contracts which clarify that LADs, liquidated damages, stop accruing when the building contract is terminated. The same new clause also clarifies that that's without prejudice to any other remedies which the employer may have. So that means that general damages can be recovered after the termination date, but LADs stop accruing. And the JCT is responding there again to a specific case, the triple point case, which established that very principle. Okay, if we can move on to the next slide. Thank you. Couple of points on ground conditions. In the 2016 contracts, there's specific provision about what the contractor should do if they discover fossils, antiquities, or other objects of interest. That's all in clause 3.15. And 2024 edition expands that clause to address other things that could be found during excavation, such as asbestos, contaminated materials, or unexploded ordnances. Now, the old, as it were, antiquities clause was a relevant event. So dealing with those things, fossils, etc., was a relevant event and a relevant matter. So it follows that dealing with these new items, asbestos, etc., will also be a relevant event, more time, and a relevant matter, more money. The new clause does also clarify that if the material was already identified in the contract documents or brought onto the site by the contractor, then there's no time or money in that circumstance. So there is that caveat. Okay, on to the next slide. Small but quite important point on PI insurance. There's now a new sort of expanded provision in the contract particulars to allow you to specify or agree what are the sublimits for your PI policy, because it will be very rare that a PI policy is as simple as £5 million cover, in the aggregate, for example. There will be lower limits for things like pollution and contamination claims, and lower limits or total exclusion for fire safety matters. And again, the JCT is responding to something very specific here. It's responding to the PI market post Grenfell, where and unless you're a specialist consultant, it's likely that fire safety matters will be excluded from your policy, or at least very much narrowed in terms of their cover. So that's all now put up front in the contract particulars. Okay, on to the next slide, please. Thank you. Just a couple of points to wrap up on just a general application. So all of the terminology now is gender neutral, and they've also updated provided for e-signature. Not that it wasn't valid before, but it's sort of specifically recognized as a valid method of signature, which of course, huge uptake in DocuSign, etc. post COVID, and the vast majority of the contracts that we arrange signature for are done in that way now. And you can also serve communications electronically as well, things like termination notices, provided it's to a specific email address. So in terms of a sort of brief wrap up, no major overhaul. I mean, nothing gets construction lawyers more excited than some amendments to standard form contracts. But these are iterative, really, sort of catch up with recent case law and recent statutes. So more of an iterative update than a complete redraft. As I said, don't go quite as far in some areas as we were expecting, in particular regarding the Building Safety Act. Okay, I will now hand over to Nicole, who's going to talk to you about case law updates.
Hi everyone. As Patrick mentioned, I'll be taking you through some recent and hopefully interesting cases which have been decided in the courts over the last few months. Next slide, please, Natalie. So we'll be looking at the effects of insolvency, choosing your words wisely in settlement agreements, and the clarification on a JCT subcontract term. Next slide, please, Natalie. So the first case we're going to look at is the Shaler Group and Valascure property case. This is a case for it concerns a contract for the construction of 157 apartments in Birmingham, and that all went a bit pear-shaped when the contractor Shaler entered administration. So it relates to a payment dispute over the payment due following the termination of that contract. And when the contract was entered into, the works valuation was just over 19 million. When termination was triggered, the works weren't complete and it wasn't looking like they were going to be completed anytime soon. And Valascure had paid in the region of about 9 million at that stage. So the key contract provision that's in question here was a financial adjustment provision, and that kicked in when the contract was terminated before works were completed. So the dispute here surrounds the wording of that provision and what the intent of that wording was. The dispute went to adjudication, and then the question that was put to the adjudicator that we'll be focusing on was, should Shaler be entitled compensatory payment based purely on the cost of the completed works at the time of termination, or the total contract sum? So Shaler's argument was that the meaning of the relevant provision was that it was the overall contract sum, and it claimed it should have received £20 million in total. The adjudicator rejected Shaler's reasoning, and it found that Shaler was actually owed money, but a substantially smaller sum of just 356,000, and that was for the value of the works that were actually completed at termination. So Valascure were unable to pay this, and Shaler brought about a petition for the winding up, and crucially at this stage Valascure entered liquidation. It's also important to note at this stage that Valascure had attempted to assign its rights and obligations under a separate building contract with another employer, Granger, who would finish the works. So moving on, Shaler brought a Part 8 claim in court against Valascure in order to prove its debt in the liquidation, and it sought to declare that the adjudicator had misinterpreted the contract term and therefore the contract sum, or the sum that was due to them. So it was now up to the judge to determine what the words "the total amount payable for the works" actually meant. Did it mean the value of the works done, or did it mean the total contract sum? So Shaler presented an argument that the answer lay in the contrast between this specific provision and the provision that would be engaged under circumstances where the employer didn't intend to finish the project with another contractor. This was worded as, the statement of account relates to the total value of the work properly executed at the date of termination or on the date at which the contractor becomes insolvent. So that was a clear difference, and it argued that the language difference showed that the provisions intended for two very different outcomes. So interestingly, the judge agreed with Shaler, citing that the adjudicator did misinterpret the contract provision and that the calculation was in fact incorrect. However, could I have the next slide, please? The judge didn't actually rule in Shaler's favour. So the judge found that firstly, due to Valascure's ineffective assignment to Granger, that provision didn't quite operate correctly and the termination calculation was skewed in Shaler's favour. But also the judge considered that had Valascure not been in liquidation and had it the funds to put forward a defence, then the outcome might have been very different. He found that declaring the overall balance owed to Shaler of 11 million could actually bestow an unlawful windfall on the claimant. Next slide, please. Oh, next slide, please. I missed one. So in summary, the takeaway here is that the case highlights that the courts do have very broad discretionary powers when deciding Part 8 claims. So it's a really interesting and important reminder as to how the courts look at cases where insolvent parties are involved. They won't just take into account the letter of the law, but they will also consider what's fair. Next slide, please. So the next case concerns Donvale Cafe Components and Hilgar Properties. This case was for a mechanical works contract, with Hilgar being the employer and Donvale the contractor, and it relates to a difference in opinion on how the wording contained in a settlement agreement should have been interpreted. So 9 months into their contract, the relationship had broken down and the contract was terminated, with both parties claiming that each other was in breach. Hilgar then issued a claim in adjudication for payment, and the total contract price of $641,000 was due, with a 40% of the contract sum being due on entering into the contract. At the point of referring to adjudication, Hilgar had paid about $350,000 to Donvale. So the adjudication was seeking a true valuation of the work that was undertaken, and it claimed a repayment of £180,000 plus VAT and interest. £180,000 plus VAT and interest, yeah. Donvale, of course, denied that any money was due to Hilgar, and it issued a counterclaim for $147,000 in the absence of receiving any pay less notice. So the adjudicator decided at this stage that Donvale was the party responsible for the breach. The value of the works at termination equated to just over $272,000. Donvale's counterclaim was irrelevant and ineffective, and that ultimately Donvale had been overpaid. Donvale were ordered to pay Hilgar's £180,000 plus VAT, as well as the adjudicator's fees. But from here, next slide please, Donvale failed to pay up, and enforcement proceedings were issued to recover that money. And during these proceedings, the parties settled and a Tomlin order was issued. So crucial to the case, the settlement agreement stated, the payment of the settlement sum is full and final settlement of any and all claims the claimant may have against the defendant arising from or in connection with these proceedings. Donvale could perhaps be forgiven for thinking that the settlement agreement had put any disputes under the contract to bed, and they may have been shocked to then receive a letter of claim for $650,000 in losses for the same breach of contract at the heart of the settlement agreement. Hilgar at that point stated his intent to refer that claim to adjudication to recover those losses. Donvale rejected this on the basis that it believed the Tomlin order had resolved any and all claims in relation to the dispute. Next slide, please. So Donvale then issued Part 8 proceedings in court in seeking to prevent Hilgar from referring its claim to adjudication. The outcome in this case saw the judge rule against Donvale, with a judgment that should spark caution when entering into settlement agreements. The judge ruled that the parties' subjective understandings of the settlement agreement were irrelevant. The wording "these proceedings" was very important. That referred specifically to the enforcement proceedings, so the recovery of that adjudicator's award, rather than the wider issues of the contract. And Hilgar's claim for losses related only to the recovery of the adjudication award, and a claim for losses didn't relate to that initial enforcement claim. So the judge basically said that had it been the intention to settle all claims, then the language used should have been more specific to make that clear. It should have made reference to the contract, the works, the disputes, rather than these proceedings specifically. Next slide, please. So in summary, it is vitally important to approach settlement agreements with accuracy and absolute clarity in the intention. Dropping the ball here could lead to very costly mistakes, and it's important to seek legal input to ensure that precise language is used and avoid any issues further down the line. Okay, so moving on to the final case, Battersea Project Phase 2 Development Company and QFS Scaffolding. This case concerns a famous Battersea Power Plant development and scaffolding subcontract. At the centre of this dispute is a conclusive evidence clause in the JCT 2011 subcontract, which relates to the final payment notice, which QFS claimed didn't bite due to its belief that the dispute remained open in adjudication. So the project had reached practical completion and the contract sum was disputed by QFS. This was generally a heavily disputed contract anyway, with 10 adjudications having been issued already, 3 of which came about in November and December of that year. QFS then issued adjudication number 11, the adjudication that's at the centre of the court case, on the 19th of December. So clause 1.8.1 of the JCT subcontract provides that the final payment notice is conclusive of various matters unless a saving provision is engaged under 182. The saving provision was relevant here and it kicked in when QFS issued its adjudication proceedings prior to receipt of the final payment notice, and it would remain in force until the proceedings had concluded. This is where the parties reached a disagreement. The referral wasn't actually served on Battersea by the agreed date of the 13th of January, and it further noted to Battersea that it intended to serve it by the 31st and again failed to do so. So Battersea argued at this point that the referral hadn't been served within a reasonable timescale and that concluded matters. Any adjudication then that was based on the final payment notice would be ineffective, having concluded under 1.8.1. Next slide, please. So what view did the court take on this? The judge broke this down into, he broke 182 down into 2 phases. The phase 1, this was the phase of the saving provision is engaged on commencement of the relevant proceedings, and that this happened wasn't in dispute. It continued to apply until the issue at the centre of the proceedings concluded. Phase 2 considers what actually constitutes a conclusion, which is the issue in this case. So the judge stated that this means a decision, an award, a judgment and a settlement. It does not include an adjudication that becomes a nullity, as with this particular adjudication. So the final payment notice therefore hadn't been concluded due to the dispute still being alive and the adjudication decision was outstanding. The judge remarked that the proceedings which have commenced will yield a conclusion, thereby engaging the second phase, unless they have been abandoned in the meantime. So essentially what the judge was saying is that regardless of the adjudication being a nullity, the referral wasn't served by the agreed date, but a conclusion still hadn't been reached. The judge took into the decision that QFS made clear that the final subcontract sum was disputed. It challenged the final payment notice, and although the referral wasn't served in time, it did come to light that there was a genuine mistake as to the late service of referral, and in the February, Battersea had proposed to settle, and QFS made clear at that time that should a settlement not be reached, it fully intended to pursue adjudication number 11. On that basis, QFS were awarded the sum of 3.2 million. Next slide, please. So this case confirms exactly what this provision of the subcontract means. A conclusion of proceedings means an award, a judgment, a settlement is reached, or the proceedings have to be formally abandoned. A nullity will not suffice. And the case demonstrates the importance of bringing proceedings swiftly when a dispute arises, and that the intention is sometimes stronger than a failure on a technicality. So that's all the cases for now, and I hope there was something interesting for everyone. And I'll hand you back to Stefan for the Q&A. Thank you.
Thanks very much, Nicole. Our other colleagues should be joining us now, hopefully, for the Q&A section. Here they are. So we've had lots of questions in. Thank you very much for those. And we've got some time left before midday, so I'll rattle through these as best I can. Lots particularly on Building Safety Act and JCT 24. So perhaps if I start with you, Emma, on BSA. Question here, how is the shortage of registered building control approvers being managed by the building safety regulator?
I would say with very blunt instruments, really. They are trying to do more training and recruitment. There has been an issue very recently with a major private building control company, AIS surveyors, who are who've recently been the subject of a creditors winding up petition. So the safety regulators having to step in and start becoming building control for up to 50 projects that are on high risk buildings that were previously being managed by the private building control company under the transitional arrangements. So they're sort of fighting fire a little bit there. They have extended the deadline for individual building control assessors to pass their competency assessment. So that was 6th of April, but it's been extended to the 6th of July, which isn't far away now. So I would have thought we'd know by now if they were going to extend that again. I think they gave about 3 weeks notice last time, so we should have known about that. And there had previously been a lot of queries and concerns raised by RICS about that, and I haven't heard the same thing this time. So I would say the timings are quite tight and it's going to be a struggle. So.
Okay, thank you, Emma. Patrick, I'll come to you next. Although this is sort of overlaps a little bit with BSA, but I'll come to you first. Why didn't the JCT go further with its BSA amendments include changes to cover higher risk buildings, for example?
Well, I think the answer to that is they dodged it a little bit, because they do reference in their new guidance notes the high risk building regime, but they say that that's just one of the projects which a design and build contract can be used for, and they've sort of dealt with them as project specific. So said the parties will need to use their own amendments. So they've sort of dodged it, really, I think.
Okay, thanks, Patrick. Emma, back to you, if I may. There's a question here that came in from a main contractor, which is, should the principal designer under the Building Safety Act hold specific insurance for this role?
Obviously, we're not insurance advisors, but I would suggest not. I would suggest that it ought to be covered by the existing professional indemnity insurance policy, but you would always need to check that with your broker. It's part and parcel of your role as principal designer. It's not a separate thing that you're doing. So it should be covered, but yeah, I'd certainly query it.
Okay, thank you. Patrick, back to you. Question on delay damages. Regarding the revised liquidated and acidated damages clause, you mentioned you can still claim general damages after termination. Can you please expand on what general damages means?
Yes, so up to the termination date, you claim your liquidated damages, which basically means damages at an agreed rate of £5,000 per week or whatever. They stop accruing on termination, so you can claim general damages after termination. So that basically it's the same. A similar principle. It's whatever losses you suffer after the termination date. But the difficulty with post-termination general damages is you've got to prove them. So obviously you're terminating because the contractor's in breach. LADs, you've simplified things because you've pre-agreed the rate of damages, so you don't need to sort of prove anything. But with general damages, you need to show and evidence what losses you're suffering as a result of the contractor's late completion. So it's whatever damages you can properly evidence, really, as a result of the contractor's breach.
Okay, thanks, Patrick. Emma, back to you, more on BSA. Question here from a developer, and it is, how does the employer's obligation to appoint a competent principal designer under the BSA fit in with the contractor's design obligations under a design and build form of contract? Will the employer's PD need to coordinate with the contractor's design team?
Yeah, I mean, what I would usually expect to see is that the contractor is appointed as both principal designer and principal contractor, where it's, accepting primary design responsibility, and then ideally the original employer's professional team, their designers would be novated to the contractor. There'll still be a designer, there'll still be a duty holder, but would be, if they're novated, they'd be appointed by the contractor.
Okay, thanks, Emma. Patrick, question about other parts of the new suite of contracts. I think you may have touched on this early on, but anyway, is there a timeline for JCT 24 measured term release date, as far as we know?
No, I mean, we've only got the DB so far. I mean, all they've said is, later this year. So they've not been more specific than that, I'm afraid.
No, just a case of watch this space, I think, isn't it?
Exactly,
for the time being. Okay, thank you. Where are we on time? We're up to midday. I'll do one more question before we finish. So Emma, question here for you from a main contractor. Is Building Safety Act, is this not just additional paperwork, and is the industry ready, as most consultants don't have BSA assessors?
I would say certainly it's more paperwork. Certainly the industry is not ready, but it's not just about the BSA assessors, it's for everybody. You know, it's part of everybody's role now, and as I mentioned, there's a lot riding on it. There's unlimited fines, people can go to prison, so it's not just extra paperwork. There's a lot to be done, and the paperwork is about proving that you've done what you're supposed to have done. So yes, from a compliance perspective, there's paperwork, but it's not a toothless tiger. Would be my answer.
Good stuff. Okay, thanks, Emma. All right, I'm going to wrap up there because we are just slightly past the advertised time. That's all we've got time for, but I hope you found this morning's session helpful. When the session ends, you'll get an opportunity to submit your feedback, and that includes a chance to put forward suggestions for things that you want to hear about from us in future sessions. So if you're able to take a moment to complete that, we always find that extremely helpful to inform what we cover next. And on that subject, our next webinar is going to be our autumn update on the 25th of September. So please do save the date if you're able to join us. Further details in terms of signing up information will be published in due course through our usual channels on the website and LinkedIn and so on. So in the meantime, all that remains for me is to say thank you once again for joining us. Hope you have a good day, and we look forward to hopefully seeing you next time.